Good morning. Happy Friday. About a week ago, in my Discord, there was talk mostly by Juan Galt. You should follow him. He's an excellent channel. Probably if you follow me, you follow him. He tends to focus more on sovereign citizens. But he posted some live streams that Ethics Instead, Joseph Brandon Pierce, aka Common Joe, that he made. So apparently Mr. Pierce got a ticket for driving without registration because according to Mr. Pierce, he had gone to essentially a scrapyard, where they tow your car, and abandoned cars have the license plates removed, and so he removed a registration sticker from a abandoned plate. He believes that that in itself isn't theft, and that's fine. And he affixed it to his car, according to him. And so he's facing a ticket for it. And in addition to that, he alleges that he was attacked by a dog. Witnesses allege that the dog had a ball in its mouth and was just wanting to play. But he shot the dog and killed it. And so he's facing a separate trial for that. Now, he made a lot of assertions in his live stream because he is a sovereign citizen. I mean, he's a sovereign citizen who pretends to understand philosophy and ethics and things like that, and for some reason thinks that people should follow his ethics and his understanding of the legal process. But his understanding of the legal process is a complete lack of understanding of the legal process because there is a legal process. For example, he claims he wasn't arraigned, and he also complains that the court entered a not guilty plea for him, and yet the court entered that not guilty plea for him at an arraignment because that's what you do. He says that he wasn't explained the charges, but at the arraignment the charges are read to him. They're not necessarily... I mean, he doesn't have to, he follows the Mark Stevens line of sovereign citizenry where you just question, and you ask them, prove jurisdiction to me. It's like, dummy, you're in front of the court right now. That's pretty clear evidence we have jurisdiction over you. Anyway. So, for example, the issue with the arraignment. They read the charges. They don't necessarily have to establish all the facts underneath. The judge just reads the charge. Like, this is what you're charged with. These are the crimes that you're charged with committing. And then you have a choice. And your choice is, stripping away the legal terminology, your choice is, I want a trial, or I'm just going to admit, essentially, that I would lose a trial and avoid the trial. Those are your choices. A lot of the Mark Stevens line of nonsense is you go in there and you say, I'm willing to plead guilty today, but I just want to, understand. I just want to see the proof of jurisdiction. Blah. It's stupid. Your choices are essentially at that point, either you agree that the state has a winning case and you avoid trial, or you go to trial. Those are your two options. The judge entering a not guilty plea is essentially him coming to the realization that you're not going to plead guilty or plead nolo or whatever, despite what you're saying. And you're asking, because you keep asking about proof of jurisdiction, you're asking a proof question, you're wanting trial. So he enters the not guilty plea for you because that's the only plea he could enter for you. You're not pleading guilty. You're not pleading nolo. You haven't. I mean, you may say you're willing to, but your actions belie your words. So he's going to set it for trial because you're asking proof issues. You're going to go to trial. That's Law 101. Additionally, there's two things that sovereign citizens seem to universally fail to understand. Number one is the state and the court are under no obligation to prove jack shit to the defendant. Zero obligation. They don't have to prove anything to the defendant. The burden is on the prosecution to prove at various times, at various places, the case to the finder of fact. So if there's a grand jury, at the grand jury, the prosecution has a burden of proof of showing there's probable cause. At a probable cause hearing in front of the judge, the prosecution has the burden of proving probable cause to the judge. So, at one time it's a grand jury, and a second time it's a judge. If you go to trial, if it's a bench trial, you have the burden of proving to the judge. The prosecution has the burden of proving to the judge that the crime was committed and that you committed it beyond a reasonable doubt. Or if it's a jury trial, the prosecution has the burden of proving to the jury that a crime was committed and you committed it beyond a reasonable doubt. They call these the grand jury, the jury, sometimes called the petite jury, and the judge, the finders of fact. And there's different levels of proof required at different stages for different things. But at the end of the day, it's those three entities that determine what the facts are. They're called the finders of fact for a reason. They determine what the facts are. The judge determines what the law is. Now, I know a lot of people argue with me and say that the jury can do that. That's questionable. I'm not saying you're 100% wrong, but you're definitely not 100% right. The judge determines what the law is. Any findings of law, the judge will make. Any jury instructions to the jury, the judge will approve or make himself. So the judge is for most intents and purposes the finder of law. So this idea that at an arraignment that the judge, who has no burden of proof, has to prove jurisdiction to you, or that the prosecutor has to prove jurisdiction to you, is nonsense. The prosecution, generally speaking, at the early stage, the arraignment stage, generally speaking, the prosecution has to properly allege. That's it. Properly allege that a crime was committed and that you committed it. And that he has to properly allege all the elements of the crime that he is accusing you of committing. Then you go to like a probable cause hearing if your state has one, or if your crime warrants one. And at that point in time, the prosecution has to prove by preponderance of the evidence, by probable cause still. I'm sorry, probable cause still. We're still in the probable cause things. He still has to prove probable cause, which is a very low burden of proof, which is below preponderance of the evidence. Can't give you an exact, preponderance of the evidence is 51-49. 51 in favor, 49 against. That's preponderance of the evidence. Just probable cause is somewhere below that. And no court that I'm aware of has ever given a probability ratio of probable cause. He just has to prove a crime was probably committed and that you probably committed it. At trial, obviously that burden of proof in a criminal matter is beyond a reasonable doubt. Who knows what percentage that is, but it's the highest bar of proof, and that's what the prosecution has to prove at trial. But not at arraignment. He doesn't have to prove jurisdiction to the defendant at arraignment. That's just nonsense. The other really big issue that Common Joe has is a perceived by him lack of accountability by the judge. He didn't feel like he was being heard. He believes that he was making arguments and etc. During the trial on the traffic issue that weren't being heard. What he doesn't seem to understand is there is a process. The process is that, for example, the prosecution makes an opening statement, the defense makes an opening statement, then the prosecution has the opportunity to present its case. And these are factual elements, generally speaking, that the prosecutor is going to be getting out of the witnesses that the prosecution presents, and the documents and photo evidence and things like that the prosecution presents. So he's establishing facts. This is where the facts are laid out in front of the judge. It's not an argument time. Remember, he had an opening argument. The defense had an opening argument. The prosecution then presents its case. It presents the facts. And then after the prosecution rests, then the defense can present its case and present its facts. And then when that's done, the prosecution, generally speaking, gives a closing argument. The defense gives a closing argument. And then the prosecution, because they have the burden of proof, they get an extra rebuttal, essentially, to the defense's closing argument. And that's where argument is. So it's a specific process, a procedure that the court goes through at a trial. Defense starts with the argument, then prosecution starts with the argument, then defense makes their argument, then the prosecution presents its evidence, and then the defense presents its evidence. Once the defense rests, then the prosecution makes an argument, defense makes an argument, and the prosecution gets the last word in an argument. At that time, then the finder of fact will determine what facts it finds credible, what facts it finds not credible. It'll give weight to the various pieces of evidence, and then it'll apply the facts to the law, or the law to the facts, whichever way you want to go. And then the finder of fact will render a judgment, a finding. I find you to be guilty. I find you to be not guilty. There's no finding of innocence. It's just a finding of guilty or not guilty. Now, objections are legal things, and they have to be based on law. They're called legal objections for a reason. So you may object that testimony is hearsay. That's a legal objection. You may object that it's not relevant. You may object that it's non-responsive. Whatever the objection is, it has to be a legal objection. If you're not making a legal objection, the court can, will, and should ignore what you're saying, because you're essentially trying to make an argument outside of the procedural points where you're allowed to make an argument. Because remember, you get an opening argument and a closing argument as the defendant. You don't get to make arguments interspersed. That slows the trial down. It's improper, and the court is right to ignore untimely argument. And the court is right to overrule unwarranted objections. So, Ethics Instead's issue that he wasn't being heard, that he was talking and no one was responding to him, is most likely because he is not presenting evidence at that time. It was the prosecution's time, and it wasn't the time for argument. Like, he doesn't understand procedure, and so he can't figure out why things aren't working the way he thinks they should be working. They don't work the way Ethics Instead wants them to work. They work the way the process works. This is rooted in English common law for every state except for Louisiana. It's rooted in English common law. It goes all the way back to like the 1200s or something like that. It's a long system that has a lot of procedures built into it that various states have incorporated into their rules of criminal procedure and their rules of court and whatever other rules tie into it, or the rules of evidence. They're all kind of similar. That's why you could have a multi-state bar exam. They're all kind of similar because they're all based on that, 1,000 years of jurisprudence that's built these rules and systems up. And if you don't get, if you think that the court has made a wrong decision, Ethics Instead thinks there's no accountability on the court. He thinks that the bailiff should just run over and arrest the judge for not doing what ethics wants. But the issue with that is there is a role, there is an accountability that you could hold a court to. If the court makes an error, and courts make errors, your remedy is either an appeal or a petition. I think Arizona, they were called a special action, but it's just a petition. Appeals and petitions are similar but not the same. You appeal a final judgment and all of the errors that led to the final judgment, or in the middle of the action, you could seek a petition, which is a very fast process, generally speaking, to set aside a specific ruling. And every court system will have a lot of procedural hurdles you have to jump through in order for a court to hear a petition, or in order for a court of appeals to hear a petition, or a court of appeals to hear a appeal. And all of those procedural rules are, generally speaking, in some sort of a code of criminal procedure for a criminal action, rules of court, something along those lines. There's going to be specific rules. In the federal rules, you have the federal rules of appellate procedure that say all the things that you have to do in order to even get your appeal heard. You remember in Springer versus the 7th District Court, they've appealed 3 times, I believe, and the first 2 times were denied on procedural grounds, if I remember correctly. So, it just outright denied, without argument, without anything else. It's just, no, you failed to follow the procedure, so your appeal has been denied or rejected, however they phrased it. So there is an accountability. Most judges, in my experience, so this is just my experience, take this with a huge grain of salt, most judges have an eye towards becoming a court of appeals judge. Most judges don't want to get overturned. That's most judges, in my experience. Most judges are concerned with making a mistake of law. Not so much mistake of fact, because they're the finder of fact. It's really hard to show substantial evidence, or whatever the appeal, the standard for appeal is for an evidential issue. Most often it's abuse of discretion for making a wrong legal decision, like sustaining the objection that should have been overruled, or allowing in evidence that should have been excluded, or basic legal or procedural issues with the court. And then the proposed remedies that Ethics Instead also have giant issues with them. He proposes essentially 2 remedies. Number 1, to have people call flood the court that he's in, to pressure the judge to make rulings according to Ethics Instead's understanding of the law, and or to sue the judge. Neither of which is an available remedy. Courts have, in every state that I am aware of, judicial immunity. Prosecutors have prosecutorial immunity. If the prosecutor has probable cause, and if a judge finds the prosecutor has probable cause, and the prosecutor brings the action, prosecutorial immunity. Any decisions the judge makes in the courtroom about that case, judicial immunity. You think the judge made a wrong decision? You can't sue him for it. Your only remedy is a petition or an appeal, depending on which one is appropriate for the situation. That's your remedy. Judicial canons of ethics, whatever they call them in your state, there's going to be some sort of a body of rules that judges have to abide by. They are bound by these rules, just like lawyers are bound by their rules of professional responsibility, or whatever your state calls them. And lawyers can get disciplined or disbarred for violating those. Judges can get disciplined or removed from the bench for violating whatever their judicial code of conduct is in your state. So one of the things that is consistently in all of the states that I have looked at, in the whatever the judicial ethics code is in that state, is that the judge cannot be persuaded by popular opinion. Cannot. In fact, the judge isn't supposed to even hear about popular opinion. If you call in and you get the court clerk or the receptionist or whatever, and you say, yeah, Judge so-and-so is a real poo-poo head and he should rule in favor of Ethics Instead, the clerk can't tell the judge that. I mean, if it becomes an issue Like if it's impacting the court's processes, then it can be brought to the court's attention, and then the court can deal with you. Like I believe in Lane Myers, they had an issue along those lines, not where it was calling the court, but was calling, there were other people harassing the witnesses, the victim, and etc. And the court can address it with the defendant and tell the defendant to knock it off. But the court can't be, the court cannot, under the Code of Judicial Ethics, whatever it is in your state, cannot change or allow that to affect his rulings. Cannot. So it's literally not a remedy. And if the court does, then guess what? The prosecution most likely can petition for writ or file an appeal based on that error in the process. Because it would literally be an error. The judge would be making an error that would be appealable and or you can get a petition for. So his complete misunderstanding of the procedure in court, and I've read his motions. His motions are all garbage, just pure unadulterated garbage. The court shouldn't consider them, or actually the court should consider them, but should overrule them, deny them, whatever. But they're just garbage. They're hot, stinking garbage. He has no understanding of the law and no understanding of the procedure. But with that said, he wants to be featured on a larger channel like Long Island Audits. I think he also said something Cop Watch, one of the California Cop Watch channels. San Joaquin Valley, I think, Cop Watch. Or James Freeman. And like that's fine and everything like that. If you think you have an issue, that's fine. But like just you're not going to overturn what 1,000, 1,300-ish years of jurisprudence of court procedure by doing this. You're just not going to. That's not the way the court system works. The best thing that you could do is if you think that there's some change that needs to be made at the court level, you can either try to, influence the Supreme Courts of your state because they, generally speaking, make the rules of court, or you could try to influence the legislature of your state because they generally write the laws that determine what criminal procedure is and isn't, and they have the power to make rules for the court that even the Supreme Court most likely won't be able to ignore. So those are the remedies if you want to change it, but good luck. I mean, this stuff is rooted deep. It's not going to change. And I don't think there's an inherent problem with it. I mean, I'm not a huge fan of the grand jury system because the prosecutor doesn't have to present any exculpatory evidence, and the defendant can't present evidence, generally speaking, usually, #not all. So, the defendant normally doesn't get to participate, because normally the grand jury process is done before the defendant even knows the defendant is a defendant. So, it's not perfect, but it's the best system we got, and changing it to where you could sue the judge doesn't make any sense. Changing it to where the judge would succumb to peer pressure or to public pressure doesn't make any sense, because imagine you're just a terrible person, but, what's that, I'm not saying he did it, but that guy who shot the CEO, the healthcare CEO, he has a lot of public support. Should we just let people murder because the public supports it? Is that really a society you want to live in? It doesn't make any sense. None of these positions are well thought through what the logical conclusion would be if we actually implemented them. They're terrible. They're terrible ideas. They're terrible ideas. So I wish ethics instead good luck. Good luck presenting your evidence. I strongly recommend you get an attorney. There are procedures in Missouri that if you follow them, the court may appoint you a public defender. You have to ask for it. There's a procedure. He says, it says on the court that I can get appointed a public defender. Well, did you follow the procedure? There's a procedure there. No? Okay, well, that explains why you don't have a public defender, or else you just don't qualify for it because you make too much money or whatever. But there's a procedure. Procedural issues are annoying as an attorney, but also they're the way that you know how the system is going to work, so that you can work with the system. It's like rules to a board game. If there's no rules to the board game, it's no fun. It's not fair. That's why the rules are in place. You may not like them, but there you go. Anyway, I've rambled long enough. If ethics does try to sue the judge, it's not going to work. I mean, there's no guarantees to anything, but 99.99% sure it's not going to work. Judicial immunity will apply. It's a waste of time and effort. If you try to sue the prosecutor, prosecutorial immunity will apply. 99.9% sure. I mean, good luck, dude. And I have seen a lot of people in the community try to do these phone call pressure brigades. Like Freeman used to love doing it. They don't work. I've never once seen it work. Show me where it worked. Show me one time where it worked. And if you say, well, he was found not guilty and people brigaded it, well, yeah, great. But that doesn't mean it worked. I mean, you're gonna have a hard standard. I guess the issue is you're gonna have a really hard time showing me it worked. But it's not supposed to work. And if it did work, that's an error in the system. But I've never seen it work. So anyway, good luck, Ethics Instead, Common Joe. How about you don't shoot any dogs? That'd be great. Thanks for watching. Have a great day.